Hi everyone, and welcome to our second session. I'm not going to go into as much detail because I think most of you were at the previous session, but I'm just going to run you through some quick housekeeping rules. And in this session, we're going to be looking at what happens after offer up to the point of acquisition. So just to remind you of the housekeeping rules, we're recording this session and it will appear on Vimeo next week. My colleague has put up the presentations if you want to have a look at them. And then if you want to ask any questions for the session at the end, you can do so in the Q&A box at the bottom of the screen. And just a reminder, if there's someone you want to particularly ask, just put that into your Q&A and I'll direct the question to them. So our order in this session is going to be the other way around from the first session, because this part of the process is much more focused on the legal aspects. And we're going to hear from Calum MacLeod of Harper MacLeod first, and then we'll move on to Rebekah and David from the National Lottery Community Fund. So I'm just going to hand over to Calum now.
Thanks, Lindsay. I'm just going to share my screen just now to put the slides up.
So I don't think we can see you either, Calum, so you'll need to turn your camera.
Yeah, I did. I think it says the host has stopped my video. So I think.
Okay, well, we'll try and sort that out for you. If you want
that's it.
Yeah. There we go. There we go.
It's just allowed the video. Can I just double check? Firstly, everyone's hearing me okay, and you're able to see the slides?
Yes.
Perfect. So yeah, I'm Calum MacLeod, solicitor at Harper MacLeod. Hopefully everyone was at the first session this morning as well, because this very much leads on from the first session. So this is offer to ownership. So this is very much the legal aspects of a community purchase. I've called it phase 2, really proceeding to ownership. So at this point, you will hopefully have a community body. It's very much moved on from the idea stage, and they'll hopefully have their funding in place. They'll have probably done a valuation, got their phase 2 SLF funding approved, and have some agreement in principle with the landowner. So they're able to firstly then make a formal offer. I'll explain what that is in a second. Then progress the conveyancing of the property, and then move to purchase and take over the asset. So the general sort of conveyancing process, I would say is as follows. This isn't absolutely exclusive, but this is just the general process. So firstly, as I said, you would ideally have, from the previous phase, have agreed a price and have a general agreement in principle for the terms of the sale with your landowner, and in tandem you will have obtained funding, done your valuation. You would then ask a solicitor to prepare a legal offer on your behalf. Part of that might be having to annex a good plan to your offer, and the solicitor would prepare that offer on your behalf. You would then make a written offer to the landowner solicitors, or alternatively, you can also send the offer just as a draft document and try and agree it. At the same time, I've called this due diligence on title, but what that really means is just checking over the title deeds. Solicitor would obtain the title deeds from the landowner solicitor. You would adjust the contract and hopefully then get to a finalised position on the contract which complies with your funding requirements, complies with what's been valued. You would agree a title deed, it's called a disposition with the landowner, which the landowner signs. At the same time, both you and your solicitor should be liaising with your funders, the Scottish Land Fund, to try and draw down funds. That the solicitors in particular will have to prepare what's called a certificate of title, which is checking on the owner's title deeds firstly, so the pre-existing title deeds to make sure they've got a valid title deed, but also commenting on any new conditions that the owner might be asking to go into the title deeds. So that might be, I don't know, a reserved right of access. The owner might want to retain a right of access, or maybe there might be some special conditions which have been pre-agreed with the landowner. And you're both liaising with the funders, and you draw down the funds, provided your funders are also happy with the title deeds and the end deal that you're signing up to. When you know that you're essentially good to go, you would set a final date of entry. Typically, that might be, 3 or 4 weeks from when you have a finalised deal, if you like, a very finalised deal that you're committing to with the landowner. You need to give a bit of time to draw down funds from the Scottish Land Fund. The existing practice just now is that the funds go to you as a community body. You need to then get funds to your solicitor, and the solicitor then needs to transfer the price over to the owner, who grants you a good title deed in exchange, and then that's you completed the purchase. But I mentioned offer earlier, and I think I should clarify, well, what do we actually mean by offer? Because you might feel you've already made an offer for the land if you've already had discussions with the owner. Well, generally speaking, an offer is going to be part of the contract. So a final contract for the sale and purchase of the property or land. It's more than likely going to be a binding offer. So once you've issued it, if the landowner accepts your offer, you're contractually bound into the terms of the offer. Now, it's always required as part of the community right to buy process, and at some point it's going to be required as part of a negotiated purchase as well. You're going to need to have certainty on price, albeit you can actually make an offer that is subject to getting a valuation, or subject to even agreeing the price in terms of a valuation. So both parties could commit to a purchase and have a term of the offer that states that the price shall be whatever the valuer says it is, and you'll each get and you'll jointly get an independent valuer to determine the price. But ideally, you would have certainty of price. You would also probably want an idea of your date of entry. You would want to know what you are purchasing, so you want it mapped. Now, this is a key point. An offer, whilst you could call it a binding offer, so you make your offer, you make it in writing. It's actually only completely binding if it's accepted in full by the owner. And so a solicitor might make an offer on your behalf. It's in writing. It's actually contractually binding. But if the owner doesn't accept it in full, either party could still withdraw. And more often than not, and this happens in all types of sales and purchases of property, all types of residential conveyancing. An offer gets made and the seller comes back with some changes, which then you as purchaser would need to accept before you have a final binding contract. There are sort of other ways to do it, and I've touched on all of these earlier in our previous session at 10 AM. But sometimes you might prepare a draft offer, and that's quite good if you feel you don't need to put something out that's signed, because even at this stage of the process, sometimes some of your timescales may be a little bit uncertain. So this is quite useful if you wanted to just prepare an offer, send it to the landowners, solicitors, and you just agree the terms of the contract, but knowing that you don't need immediately a binding agreement in place, because maybe you've got quite a good trust relationship established with a landowner or whoever the seller is. But obviously none of it's binding because it's not been signed. Under Scots law, for the sale and purchase of property, the only contracts that are binding are those that are signed. So, verbal discussions aren't binding contracts for the sale and purchase of property, and that's an important point. And then finally, I was just going to mention a conditional offer. So that's a written offer, but it is binding in the sense that it gets signed, and it's binding on both parties if the owner then accepts in full. But the difference perhaps with the most normal types of offer is that it would be subject to certain preconditions. The classic one is funding. You might not have all your funding in place, but there might be a little bit of urgency to get something in writing out there that the community is prepared to sign up to. But you would put a precondition in that states that if we don't get all our funding in place, we're entitled to withdraw from the contract. So that can be quite useful in certain occasions. More often than not, though, the process will be that you've got your funding in place, you've got a valuation, you've got a clear idea of how you're going to proceed, and you can just make a written offer that would be binding if accepted. I was going to just mention some of the sort of general pitfalls I see. Quite often there might be problems with some of the title deeds. So certainly older title deeds, quite often the maps might not match what you were expecting to purchase or what the owner was expecting to sell. And sometimes there needs to be a little bit of adjustment there, or you might need to resolve issues with these older title deeds. That's less liable to happen if the title deeds are new and in what's called the land register. Some older title deeds are in an older register in Scotland. There's two registers of property ownership in Scotland: the Register of Seasons, which is older, and the Land Register, which is newer. And if there's an older title deed, sometimes when it's being transferred, some title problems can arise. You often could get issues where the landowner starts to try and impose restrictions into your title deed going forward. I've mentioned in a previous session problems with clawback and preemptions, which can affect your valuation and could scupper the whole deal. If you don't have clear heads of terms or agreement at phase one, these sort of problems are more likely to arise. They wouldn't definitely arise, but they're more likely to arise. Related to that is, if your final offer contract, what your solicitor, if you negotiate something to A, what you've agreed in principle, B, what you've got funding for, or C, what the valuation assumes, then that can also lead to problems. Timescales as well, it's a long process, and often maybe a solicitor in the conveyancing process is at the very, well, it is at the tail end. You know, you've done your feasibility studies. It's you've put in a lot of hard work. You've got evaluation. You've got the community support. You've got the landowner. The landowner's agreement to proceed. You get your funding in place, and you think that's it. We've got our SLF funding. It's going to be very quick, and then it goes to the solicitor, and you know, there might be problems with title deeds or you know, any of these issues. And I think you also need to bear in mind the timescales for drawing down your funding. There'll be funders that have timescales that you need to meet. SLF have their own timescales to meet as well for the conveyancing. I often suggest that, you know, it's always better to speak to the solicitors at phase one, just so they know they can gear themselves up, so they know that when the funding's in, they've got to move within these timescales. And you know, a general pitfall as well, what you do or don't do in phase one, you know, trying to get things as agreed in principle could cause I guess a pitfall in this phase, the conveyancing phase. I don't know if any of the delegates here, whether they're purchasing rural land or croft land, but what I would say is that in terms of title deeds and mapping problems, the purchase and sale of urban properties tends to be a bit more straightforward, at least with regard to title problems. Certainly there could be complexities in negotiations for urban properties, but in terms of just title deeds, generally speaking, and this is just a generalization, but generally speaking, urban properties can be a little bit more straightforward in terms of their title deeds. So if you're dealing with a rural land purchase, especially large areas of rural land, you can find you get to difficulties with, firstly, the mapping, often for crofting or non-crofting rural estates. So there's some of the larger, more headline grabbing community buyouts, they've got thousands of acres to map with hundreds of small bites being taken out. So, and you know, you've got the problem getting the mapping done after months of having got, you know, it's going to take months to get that mapping done following getting funding. And it can be difficult to make a binding offer in these circumstances, and that often impacts on timescales. There's questions about costs as well for that mapping if you encounter problems there. So I would say mapping of rural land tends to be a problem I often see as a solicitor. And final thing, obviously, is just, you know, if it's taking a long time, you need to just ensure you keep that landowner support as well. If you had a good relationship with them and they hear you've got the funding and then it's taking a long time, you're having to juggle that as well as juggling the community's expectations. All in all, you know, I would say every transaction is different. So, you know, I think I always say take early advice and, you know, speak to solicitors as early as possible, even if you're not going to actually engage them. And I'm certainly happy to answer any questions.
Thanks, Calum. That's really helped to demystify that part of the process. I'm going to move on to Rebekah and David now, and we'll take any questions for Calum at the end of the session. So let's hand over to you, Rebekah.
Thank you. I've just shared my screen, so I hope everybody can see that and hear me. And oh, let me just sort this out. So hello again, just to recap that David and I are speaking from the perspective of the Scottish Land Fund and the current fund, which has been running from 2016 and is just coming to the tail end now. And our experience is based on hundreds of groups who have successfully acquired assets over the years. So I think we're here to reassure you that it can be done, even though there's times when it does seem to be difficult. Just to recap briefly about the Scottish Land Fund, it's open to organisations in both rural and urban Scotland, which are community-led, community-controlled, and defined by a geographic area, so place-based organisations. The current round of funding offered grants between £10,000 to £1 million for the purchase of land and land assets, so buildings or similar. And although we've just closed 2 full applications for stage 2 funding, the acquisition funding, we are still open for support and advice through the Highlands and Isles Enterprise case officers, and also for your development funding to identify if your potential asset is one that you want to pursue to acquisition. The Scottish Land Fund pays up to 95% of project costs. There was some questions about this earlier, including acquisition and legal costs. But most groups now will have a range of funding sources for their acquisition and development funding, just in recognition that funding is competitive. It was mentioned earlier about the price of your asset, and we've talked already about valuations and the importance of getting an independent valuation just before you apply for your acquisition funding, so that your valuation is live. Price can be contentious because, not surprisingly, the seller is working to get the best price for their asset. But we will always remind you that this is a negotiation and you don't need to accept the first sale price from the seller, as their expectations may be different from yours and very different from what the valuation comes up with.
Sorry, Rebecca, can I just stop you for a second? We can't see your slides. You said you had more slides to share.
Oh, are they not up?
No.
Apologies.
No problem.
Is that them showing?
No, it's no.
No. Okay, I'll try that again. It's showing that I've shared the screen.
That's it coming up now, I think.
Oh, apologies for that.
No problem, thanks.
Thank you for saying that. It's sort of working in a bit of a vacuum here. So we were saying that the Scottish Land Fund, where groups can apply for 95% of the independent valuation. And we'd just like to share with you as well that the independent committee who make the decisions on the funding for the acquisitions are not keen on situations where the group agree to pay significantly over the valuation, because that impacts upon the value for money for the acquisition. Timescales were discussed earlier, and we look to ensure that decisions are made as quickly as possible, but in recognition that there is a lot to be done to identify what asset is viable for your community. A lot of the groups that we work with can take more than a year to even get from their initial ideas and looking at a potential asset and whether they've got community support through to making an application for funding. We have had a small number of groups with time-sensitive applications that we were able to support more quickly, but generally these are an exception rather than the rule. So I think most groups get set in for the long term and realise that if something's worth doing, it's worth taking the time to get things right from the outset, so that there's not any problems encountered at a later stage. Stage 1, the development of funding for your ideas. The decision making for that is held on a regular basis. So from application to decision is usually just a couple of months. Whereas the stage 2, which the acquisition funding, which reopens next summer, that's usually within 4 months. Once you've got the award of funding, that's when the hard work starts for groups, because you need to, as Calum's identified, work through the legal processes to acquire the assets. And David will talk more about the support that's available from your funding officer to help you through that grant management process and to owning the asset. I would just like to just manage expectations that our funding officers and our team are not legal experts, so you'll need your own advice on that. In terms of timescales, the average time from award to ownership for the 116 groups that we've recently worked with has been 6 months. And that can range from groups taking 6-7 weeks from their offer of award to ownership, to other groups that can take significantly longer, as Calum's identified, where it's a complex crofting estate or similar. Some of those can take years, though they do tend to be the outliers. In terms of hints and tips, the first thing that we would say, and this has been mentioned a lot today, communication and transparency is vital. And it's important to be clear about what's happening and why, because it's quite normal to have delays and periods when it appears there isn't much happening in this process. And that's where it's important to keep your community on side, and as Calum mentioned, keep your seller on side so that they remain willing. Utilise the skills that are available in your community and seek advice from others who've been through the process and any professional advisors out there. As Calum's identified, be clear about what's included in the legal agreement, including any conditions that the seller is proposing. Conditions such as clawbacks, burdens or preemptions could be problematic for funders, including the Scottish Land Fund, particularly if they inhibit your group's ability to deliver your development plans. So be very cautious about what you agree to at that early heads of terms stage or in the early negotiations, and take advice about what the implications of them could mean for your asset and your community. We frequently hear that groups are surprised about how much needs to be done following the funding award, and be realistic about what can be achieved as a group of volunteers in your own time. And if you need staff support to do this, experience from groups who've worked through the process is that staff with specialist skills can make an enormous difference to what can be delivered by a community-owned organisation, particularly if you've got complex development plans or refurbishment of a building, for example. And to date, groups have been able to apply for short-term revenue funding from the Scottish Land Fund to enable them to employ, for example, a development officer. But this is short-term funding, so your business plan would need to be clear about where any future revenue funding for staff is going to come from. We would always advise that you take time to celebrate achievements, because this process can be time-consuming and can be challenging in places. So celebrate those good times when your seller's willing to work with you, when the community support your plans, when you manage to secure the funding and then acquire the asset. And this is a great way of engaging with the community as well. And there'll always be people within your community who will only begin to engage with the process when they can see you making progress and believe that the development can actually happen. And just finally, from your business plan, identify some quick changes that you can make for the first few months of ownership so that people in your community can start to see and feel the difference that comes from owning the asset. We've seen groups who put up clear signage on day one that says that this is a community-owned asset. Sometimes they manage to get the local school involved with the artwork and the competitions and the like, so that it's really clear for visitors and local people in the community that this has actually happened and the community owns the asset. Thank you. I'm happy to take any questions, but David's now going to speak from his experience of working with groups.
All right, I'll do that. Good afternoon, everybody. I think Lindsay will need to start my video.
I'm just going to ask my colleague to do that because I'm not hosting this. There you go.
Okay, thank you. Can everybody still hear me?
Coming through loud and clear, David.
Okay, I've got a strange thing on my screen, but I'll plow on anyway. Good afternoon, everybody. As I say, I'm David Knight. I'm one of the funding officers working on the Scottish Land Fund, and I'm one of the team that would actually deal with managing the grant once the award's been made. So I thought I'd take the opportunity to, if you like, talk through the nitty-gritty of what you can expect once your application has been successful at Scottish Land Fund committee meeting. So the first thing that happens is that shortly after the meeting, you would receive a phone call, usually from your case officer, to inform you of the decision and give you any feedback that came from the committee. That will be followed a few days later by a formal offer letter. Again, the letter will outline the amount of funding you've been awarded and contains terms and conditions of the offer and any additional terms and conditions that the committee might have added. You will get 28 days to accept the offer. And really the ball's in your court then to how quickly you want to turn it around, but we would advise you to read any offer letter very closely, check the terms and conditions, and if you're satisfied, sign the offer letter and send it back. Once that happens, we've then got a contract, and your funding officer would then go through an induction meeting with you. And basically that's to explain how the grant would be managed. Now, the bad news is that we don't pay the funds up front. So you shouldn't expect to get a huge amount of money suddenly appearing in your bank account. The way we operate is that, in particular with capital funds, we will release funds on the basis of cost incurred. Now, what that means is that you don't need to have actually paid an invoice, but we will release funds on the basis that you have an invoice to evidence that you need to pay that cost. This is slightly different to some other funders. And again, if you're doing joint funding with an acquisition where you're using other funders to match fund or to contribute towards the overall cost, it's important to check with them how they pay their funds out, because it can affect your cash flow. We pride ourselves on being extremely quick at releasing funds, and we have a payment run every week. And if a claim comes in on a Tuesday, we can usually process that claim, include it in the following day's payment run, and it's in grant holder's account, usually on the Friday or the Monday, a few days later. In relation to an acquisition, we will release the funds just prior to the point at which you are going to settle, or if you like, need the funds to actually settle the transaction. And as Calum mentioned earlier on, you've got to allow time for this, because the funds will go from the lottery fund into the grant holder's account. The grant holder then has to arrange to transfer the funds to their solicitor, and then their solicitor needs to transfer funds to the seller to settle the transaction. All of that can take a little bit of time because funds need to clear in the account. Say we release funds on a weekly basis, and if you miss the Tuesday, then you're waiting 10 days for it. your funding officer will keep you advised on this process and remind you nearer the time. But we have had occasion where we've had a phone call to say, we're settling tomorrow, can we have the funds? And the short answer to that is no. Once an offer's been accepted, again, you need to settle your legal fees, and we would ask for what we call a state for settlement, and Calum would probably cover that. But basically, that's a fee note from your solicitor that contains all the costs that have been involved in the transaction, and we would then release the funds for the legal fees against that state for settlement. Again, we can be fairly quick about this. As Rebekah's already mentioned, all of this can take some time, and although we have had some grants where we've been very quick to settle, most grants we are finding, most acquisitions are taking at least 4, 5 or 6 months from the point at which you know you've got the funding to the point at which you actually take possession of it. And during those months, we've already mentioned, it is important to keep your community informed. Even if it doesn't seem as though anything's happening, they will be expecting to get some update, even if it's just a case of saying, we're still going through the legal process. Once you've taken acquisition, my advice, and this is actually nothing really to do with the legal process, is take a little bit of time to draw breath, have your celebration or a community activity or event to celebrate the actual acquisition. But at that point, a lot of groups have benefited by going back out to do a bit more community consultation and have another look at the business plan, because as Rebekah mentioned, we've had a lot of examples where the community, members of the community don't get engaged as much as they should, because some don't think it's going to happen, some think the whole thing's pie in the sky, and then all of a sudden you've achieved your acquisition, it's actually going to happen, and at that point they can engage and actually come up with some good ideas that perhaps were not included in the business plan or thought about prior to actually going through the process. The other thing to remember is your business plan by that time could well be a year or 18 months out of date, because you prepared it for your funding application and obviously things might have moved on. So it's a good opportunity immediately after acquisition to have another look at the business plan and perhaps refresh it, because at the end of the day, shouldn't be a fixed document. It's a document that should evolve as your project evolves. That pretty well covers the things I wanted to talk about. So I'll hand you back to Lindsay for any questions.
Thanks, David. I think we've got quite a few questions, some of which would be for you and some for Calum. So I just asked the first one, I think maybe for Calum, about what the implications are in terms of title and liability when it comes to services, gas and water, etc., traversing the land.
Okay. That's probably a seminar in itself, to be honest. There's a whole host of things to consider, I guess. I mean, we're talking about public services. Water, it could be a private water supply. I don't know. I mean, it's going to depend on the nature of the services. If it's public services, obviously there's less liability requirements. I don't know. It depends on the nature of the land, what you're purchasing. You're also looking at what legal rights are in place. Do third parties have rights to these services, etc. Yeah, I mean, there's a whole host of things. I think it's it would very much depend on the nature, but it's something always to be mindful of. It's more likely to be something that's an issue in the sale and purchase of rural land where the water supply pipes, for example, might be private, and that can often be the case where a property is on the public water supply but is actually served by private pipes, which wouldn't be maintained by Scottish Water. The responsibility might be on either the owners of the land or the users of the pipes. But yeah, there's a few things to consider.
Thanks, Calum. The next question is maybe one for Dave Thompson at the Scottish Government Community Land Team, who's not here today. So I'm going to see if anyone knows the answer to this question, and if not, we'll talk to Dave and get the answer back. But David Knight, I just wondered if you had any experience of that, where groups going through community right to buy and the landowner tries to claim back expenses. Is that something that you would get involved in, or you would, see as completely separate from the work that you do at the Scottish Land Fund?
Well, if a group has incurred the cost, then obviously it's something we could look at. Normally, we would not cover a seller's costs. There are exceptions to that. If, for example, a seller has given a significant discount, then we could consider, for example, covering their legal fees. Again, likewise, if there are costs involved going through the community right to buy process, then I think there is a mechanism where that particular process, they can cover some costs. But if not, again, it's a legitimate cost. That's something that we could potentially look at. But each circumstance like that is different, and I've not had any experience of that side of things. It tends to be the seller wants their legal costs covered, which, as I say, the short answer to that is no. But if they're giving a big discount, then I think it's fair enough that we should consider that.
Thanks. Calum, could I just get you to give, or do you want to say something on that, Calum?
I mean, I agree with David's points regarding negotiated sale. On the specifics of the community right to buy, I think there are provisions in the land. I need to double check, but I think there are provisions in the Land Reform Act that allow landowners to claim compensation for costs incurred in complying with the legislation. But my understanding is the claims made to the Scottish ministers rather than the community body, so it wouldn't be on the community body. So
well, I'll check with the community land team and government and come back on that one.
Yeah, off the top of my head, I believe there is some provisions. I don't think they're used that often, but I think the liability is actually with the Scottish ministers rather than any community bodies.
Could I ask you to give a quick overview of what rights of preemption means?
Okay, so to rephrase a right of preemption, a right of preemption is a right of first refusal over land. So if an example of a right of preemption would be in the event that, so if a landowner wanted a right of preemption in, then they would say that in the event that the community body sells, so they've sold to the community body, and then we put a condition in the title deeds to say, in the event that the community body sells, they need to give the landowner the first right of first refusal. Now, the difficulties it can cause, there's a few potential difficulties. The first is that it's a total pain, but the second, I guess, as things we've mentioned earlier, sometimes it could state that it's got to be a right of first refusal for £1, which then has huge impacts on valuation. But more often than not, I mean, I would expect a right of preemption to be on the basis that it's to match, you know, someone else's offer. So if a community body is looking to sell the land or part of the land, then the right of first refusal might be for the landowner to match that offer. They're usually best avoided, though.
I've got a similar question about whether clawback and preemption can be dealt with outside the purchase of land.
Well, I'm not quite sure what you mean by outside the purchase of land, but if you mean not going on the title deeds, then it's still a condition that affects the community's ability to deal with the land. Well, if I was a solicitor dealing with that, and we said, right, we're not putting this on the title deeds, but we're still going to have a right of first refusal with the landowner, I would feel compelled to disclose that to the Scottish Land Fund and say, well, you know, there is a right of first refusal on it. You know, it's still there. It's still is a restriction on the land. So I don't, you know, I don't think it should be seen as something, you know, that there's a way to get around this by just offering the landowner a clawback or a right of preemption and not telling your funders. I don't think that's appropriate. Maybe David and Rebekah probably hopefully take the same view.
Yeah, I would completely agree, Calum, because the reason that there's concerns about the conditions that some sellers propose on asset sales is because they can inhibit the ability of the group to develop their plans. And these are the plans that the funding has been exchanged for and the outcomes that the funding is going to be delivered for. And we don't want anything that's going to stop you delivering your community plans. And the Land Fund's not the only funder that has concerns about these. So conditions on the asset and how you use that asset could stop you getting development funding in future, and that's absolutely not what we want.
Thanks, Rebekah. We've got a question about accessing CC and search sheets on Register of Scotland and it costing £20 for communities, but solicitors get a lower price than that. I'll just say something before I pass it on to other people for comment on that Development Trust Association of Scotland runs a service called SULU, Scottish Universities Land Unit, and they can help get access to search sheets. And Community Land Scotland, we've also got a business account with Register of Scotland, so if a group finds itself really stuck on that front, it's something we can help with. We're definitely not experts in searching the land register, but we can get access to that for the lower cost for people. I don't know if there's anything else that you want to say on that, Rebekah.
No, not specifically on that, but I think that reiterates why it's important to seek all the sources of advice and support that are out there, because some can help save you money as well.
Mm-hmm.
We've got a question about whether freedom of information.
I was going to make a couple of weeks.
Yeah, go ahead.
That one, I mean, I can't really comment on the Register of Scotland's pricing policy and why they charge a bit more. I don't know if the £20 includes a little bit of advice on searching. I'm not sure. I do know that trying to search for a seizing search sheet though takes a lot more time. I think the wider though public policy debate though is about completion of the land register. And this is maybe just an example as to why the land register should be completed. And I know the Scottish Government are aiming to complete the actual land register, so that's getting all seizing properties into the land register by 2024. I think they're way behind target on that, but I think that's just another example of why it's so important to complete the land register. Costs and time for searching for properties that aren't in the land transparency transparency about ownership of land. It's, you know, really important. So I think, you know, the solution to that would be get the land register completed as soon as possible.
There's an interesting question, which is a good question to ask, about whether valuation is likely to be different between a district valuer and other valuers. Do you want to just answer that, Calum, first, and then I'll ask others if they've got comments?
Yes, strictly it shouldn't be. I think the question isn't so much about DV valuation against other valuations. I think the question is about the independent valuation that you require for the purposes of your funders against what a landowner might have valued the property at, because, you know, often landowners might have their own agents and they'll have said this is the valuation, and you know, and that's often done by a professionally qualified surveyor saying that, so it's, you know, going to be difficult for a community to necessarily argue against that. But what you'll quite often find more is that then when you go to the independent valuation, they've got a different view. So I think the key aspect is that someone's doing an independent valuation under the RICS, I think is it called the Red Book, certain standards, because you could get a valuation, the landowner could give you a valuation, but that's you know, that could be a bias valuation. It's getting that key independent valuation that's being carried out under certain standards that's the critical one, whether that's done by the DV or whether it's done by another independent valuer.
David, is there anything that you want to add to that from your perspective?
No, I think Calum covered that quite well. I was going to talk about how COVID was affecting processes.
Go ahead.
Yeah, and what I can say is, yes, it's having quite a significant effect. For example, we are getting people who are trying to register as a SKIO with OSCA or as a charity with OSCA. Now, to give you some idea of the problems they're facing, they've got a backlog of registrations and some staff off. And the last time I spoke to them, they're only now, here we are, well into November, they're currently dealing with registration applications dating back to June, which means that if you are waiting to form your organization in order to be eligible for a grant, you've got that delay. That also has a knock-on effect to getting a bank account. And again, we are finding there are delays in bank accounts being set up. So when you put those two together, you know, what used to be a fairly straightforward system, which maybe took a few weeks, is now taking anything up to 6 or 8 months to complete. So again, these timescales are currently having to be factored in to funding timescales. In relation to once everything's set up, it's certainly our own timescales are not being impacted in that we're able to deal with applications, put assessments to committee, make awards and so on and so forth. But once the award's been made, this is where the impact of COVID is certainly slowing things down.
Thanks, David. I've got a question about where public bodies own land, whether it's possible to use freedom of information legislation to discover the contents of deeds. I don't know if anyone has tried that before, anyone has got the answer to that question. We do often get asked like from communities how they can see the contents of deeds owned by public bodies, but I've never come across anyone that's found a solution to that. So I think the answer to that is we don't know. Just hopping between the Q&A and the chat to see if there's anything that I have missed. There's a question about
I
Sorry.
was maybe saying that last point, is the answer maybe under the Community Empowerment Act? I don't know whether, I'm not sure freedom of information is the answer, but maybe it's only surplus assets public bodies are meant to keep a register of under the Community Empowerment Act. I suppose technically most deeds are publicly available for a fee anyway, so I suspect any FOI answer might just refer people to the Land Register or the Registers of Scotland. I suspect, don't know the exact answer.
There's a couple of questions about district valuers, one asking whether you need to pay the district valuer, and another asking if there's any advantages or disadvantages of using the district valuer compared to just a normal RICS registered surveyor. Does anyone have any comment on that?
So yes, you would need to pay a valuer, and that can be a legitimate SLS stage 1 cost. As we've said before, the important thing is being clear about the basis of that valuation. So that's understood by yourselves as the community group and by the seller. We see the independent valuations being undertaken by the DV in some areas of the country because that's who is available, or by the independent valuations. I think it depends who's available in your area to do that. In rural areas, it has traditionally been the district valuer who's been available and has done a lot of these. But yes, you have to pay for them, but there is potentially funding there.
I think we've come to the end of the questions now. I can't see any more that we've missed. So yeah, I'd like to say a massive thanks to David, Rebekah and Calum for presenting today. I think these presentations that we've recorded will be encouraging groups to watch in the future, because I think they're going to be really invaluable for groups that are coming through the process and working their way towards acquisition. So thanks to everyone today, and thanks to everyone who's tuned in. Hopefully some of you will be able to join us at 2 o'clock for the next session, and a reminder again that if you could just hit the leave button and then tune back in at 2 o'clock if you're viewing that session. Thank you.
Thank you and bye.